General, if I could take you back to the discussion that you were having with Justice Barrett about the conscience objection, and just ask you, I'm sure that you've read the declarations carefully, and I'm sure Ms. Hawley will have things to say about this too. But as you read those declarations, what is the conscience objection? What are the doctors objecting to exactly?
I think the declarations are specific on this point. There are only 7 doctors who regularly practice and submitted evidence, and the declarations are relatively short. This is at JA 150 to 200. I encourage reading them because there are only 2 doctors out of the 7 who even provide any information about their specific conscience objections.
Those 2 are who?
Those are Dr. Skop and Dr. Francis. The relevant language for
the other 5 don't refer to conscience objections.
They don't refer to their own conscience objections or provide any specific detail about exactly what care would violate their conscience. Dr. Francis is at JA 155. Dr. Skop is at JA 167. Both describe the injury in the same terms. They object to ending the life of a human being in the womb and fear that they might have to complete an abortion for a woman who has an ongoing pregnancy.
So as you understand those declarations, they do not object to providing whatever care is necessary to a person who may have complications from taking mifepristone. In other words, for example, suppose somebody has bled significantly, needs a transfusion, or any of a number of other things that might happen. As you understand the declarations, there's not an objection to that.
I think that the fairest reading of the declarations is they are not objecting to that. Now, I acknowledge that respondents in their red brief have suggested there's a broader conscience injury in play here and that there might be other doctors who have a broader concern about providing any care. Even if that broader conscience injury had been in this declaration, we think still as a matter of law, they could not demonstrate that they have a non-speculative injury, in part because of all of the upstream things that would have to happen in terms of a woman having the serious event, going to these specific doctors, but also the fact that federal conscience protections are specifically designed to deal with this issue, and they would cover the range of conscience objections that exist in this context.
Right, there are obviously conscience objections of all kinds. I was just asking about the particular declarations of these particular members of the
Yes,
organizations.
and I think on these declarations, they have not asserted a broader injury, but even if they could conceivably come forward with other doctors or try to adjust their declarations in some way, still that would not suffice.
Okay, can I just ask a quick question about the merits? You open your brief with a somewhat arresting statement, but it starts with "to the government's knowledge," and this was written a few months ago, and since then I'm sure that you've had lots of time to think about this case and to get all background information on it. So I'll just read you this sentence and ask you whether it's still true, to the government's knowledge. To the government's knowledge, this case marks the first time, and I'm going to say, is it the first time? Is it the only time? Any court has restricted access to an FDA-approved drug by second-guessing FDA's expert judgment about the conditions required to assure that drug's safe use. Is it still the only time?
That is still, to our knowledge, the only time a court has done that. We have seen a disturbing trend of courts sometimes also overriding FDA's judgment to try to grant greater access to drugs when that overrides FDA's expert judgment about what's necessary to ensure safe use. And no matter which direction you come at it from, we, on behalf of FDA, think that courts have no business making those judgments in the absence of the kind of arbitrary and capricious error that would satisfy the APA.
Thank you.
Justice Gorsuch.